It's Jen again, and today I want to talk to you about this paper that I found online. I'm always looking for papers, I'm always looking for something new to read, and I found this one online and I found it especially interesting. I really love the title though. They call it Statutes with Multiple Personality Disorders: The Value of Ambiguity in Statutory Design and Interpretation. This article is from 2002. It's from the University of Michigan Law School. I found it fairly easily. Here's the website if you would like to look for it. It's https://repository.law.umich.edu/article/1400. So this paper talks about how Congress writes vague laws. They do it purposefully, knowing that they're not really vague, but that most people don't exactly know how to read them. So they write these vague statutes for the agencies, and then the agencies are allowed to interpret them in the way that they see fit. Once the agencies interpret the statutes, they're allowed to interpret it in the way that they choose, and the judicial goes along with that. So whatever interpretation the agency decides fits them, the justice goes along with it. So whether it be the intent of Congress that the statutes be interpreted rightly or wrongly, doesn't matter. It only matters that the agencies are allowed to interpret them. So in this article, Joseph A. Grunfest and A.C. Pritchard really tell a lot of information in this, and they do the arguments back and forth about whether the statutes are vague and whether they're not vague. And they argue that they are vague to a point. They're vague because people don't really know how to interpret them, and they don't understand the form in which a statute must take in order not to be vague. The agencies that interpret them, they don't understand those forms. And so they take them as being vague when they really just don't actually know how to read them to understand that they are not vague. However, vague or not, the agencies are allowed to interpret the statutes, and the judicial has gone along with it, which means that either the judicial department knows that they are vague and doesn't care, or that they know that they are not vague and doesn't care. Either way, the agencies are allowed to, according to the Justice Department, interpret the statutes in whichever way they choose. So I'm going to read some of this, not all of it, and I hope that you will go and find this paper and read it for yourself. So before I start reading it, I'm just going to tell you a little bit about it. So the statutes really either say nothing, or the opinions of the justices on the agency's interpretation says nothing. You can't figure it out, and I can't figure it out, and they can't figure it out, so they interpret it. Okay, so the agencies are left to interpret the statutes, and as a result, they use force against private citizens because they believe that the statutes apply to all, where the statutes actually apply only to within the federal government, those within it. Okay, so then they end up using force against private citizens who are outside of the jurisdiction of the federal government. If you've been paying attention to the Trump impeachment trials, you may have heard Trump's attorney, Michael Vander Veen, make a statement that the Senate or the Congress lacked jurisdiction. Okay, so what that means is, for that purpose, under those laws, the Congress had no power to bring the impeachment trial to the floor and to charge Trump with being impeached. They had no jurisdiction. Jurisdiction is power and authority. So when the agencies are left to interpret statutes, they're interpreting as having a power or authority that they don't actually have. And then the justices are going along with it and letting them interpret their own authority. Okay, so it's up to us to make sure that we tell them that they're outside of their jurisdiction, because nothing the federal government does is supposed to reach to private citizens. And you may have seen Trump in a few cases and in a few things that were written by his attorneys, that because he was now a private citizen, because he left the government, that the impeachment was outside the jurisdiction of the government. So they tell you you must comply and that it's the law, but it's not the law, it's just their interpretation of the law. They interpret it to be a law because it suits them, it benefits them. So the justice then issues vague decisions, which rarely say anything at all, siding with the agency's interpretation, no matter how right or wrong it is. So in this highlighted portion of the paper, this is the introduction, it says, ambiguity serves a legislative purpose. When legislators perceive a need to compromise, they can, among other strategies, obscure the particular meaning of a statute, allowing different legislators to read the obscured provisions the way they wish. Legislative ambiguity reaches its peak when a statute is so elegantly crafted that it credibly supports multiple inconsistent interpretations by legislators and judges. Legislators with opposing views can then claim that they have prevailed in the legislative arena, and as long as courts continue to issue conflicting interpretations, these competing claims of legislative victory remain credible. So this is like an ego measuring contest for the legislators. And as a result, we're all suffering for it. And it's turned the system on its head and made it look very illegitimate and actually become illegitimate, because they're not doing things for the reasons that they should be doing them. They're doing them because it satisfies their ego. Formal legal doctrine, in contrast, frames legislative ambiguity as a problem to be solved rather than an opportunity to be exploited. Down here, judges can respond by strengthening their own interpretive technology in order to frustrate the legislators' efforts to obscure. Okay, but they don't do that. They just keep issuing vague opinions on the side of the interpreter. Indeed, there is evidence that judges also practice conscious ambiguity as part of the art of judging, when courts rely on vague language or avoid critical issues in order to craft decisions that maintain judicial coalitions. The Supreme Court's strongest proponent of precision in statutory construction, Justice Scalia, has gone so far as to observe that the High Court has the ability to write an opinion so that it says almost nothing if that suits the court's purpose. The legislature has a clear incentive to vague ambiguity because it facilitates compromise. It also does, in my opinion, the opposite, which may be beneficial in some cases. And when I say beneficial, I mean beneficial to someone's ego, not beneficial to doing what is right, not beneficial to the people. A rigorous test of this hypothesis requires the identification of a statute that was enacted as a result of a compromise rooted in willful rather than inadvertent legislative ambiguity. So it's saying that it is willful. It's a willful thing for these people in Congress to write legislation that's ambiguous and vague. It suits them. That way they can basically do whatever they want. Judicial ability to interpret would prevail over the congressional capacity to obscure if the courts were to coalesce quickly on a uniform interpretation of the statute. So if the courts would actually do their job and become uniform, it could help stop the obscuring of the intent of the statutes. So the justice could fix this problem, and they don't. But it says, on the other hand, if the courts were to disagree over the proper interpretation of the statutory language, and if their interpretations remained diffuse over time, the congressional capacity to obscure would prevail. So I guess this is like a catch-22 situation. You're damned if you do and damned if you don't. No doubt, a Supreme Court decision interpreting an ambiguous statute constitutes a final decision on the question presented. The legislative capacity to obscure can prevail in this larger super game. That's what it says right here in this super game, even if it is preordained to fail when the Supreme Court interprets individual statutes, as long as the Supreme Court's ultimate decisions are random over a series of independent statutory interpretations. My power went out here. I'm in South Texas, and we have a winter storm here, highly unusual for this area, but that would explain the change in lighting. Hopefully you can still see this. And these are just things that I have picked up that I am reading that I thought were important. So some of this may not make sense when you're just reading a line here and there out of it, but I just want to hit on some important things. I want to get you thinking, and maybe download this paper and read it for yourself. It says here 111 pages, but there's usually a lot of footnotes at the bottom. It's not actually really a lot to read. Their interpretations often represent the law of a statute for the first few years after a statute's enactment. The sample could also allow for tests of various legal realist hypotheses. And I found it interesting when I looked up legal realist to find out what that meant. So I'll leave that a mystery for you, and you can go out and seek and try to find the information on your own. So I had, I had printed this out, and so I don't have any more highlights on this paper, but I do know that he goes on, these two people who wrote this paper go on, and it's a really interesting paper to read. I'm going to read a little bit more from this section. It says, ambiguity and mixed strategies. Well, here, let me start up a little bit higher. Interpretation, ambiguity, and equilibrium. The concept of bargaining in the shadow of the law is now a staple of legal analysis. We suggest that crafting and interpretation of statutory language involve a simultaneous bargain in which the legislative and judicial branches negotiate in each other's shadow. Interesting. So the three branches that are supposed to be separate are actually all working together in this legal shadow in these statutory ambiguity games. The process of statutory design and interpretation can be molded as involving three games. First is a legislative game, in which a legislature develops a coalition sufficiently large to support passage of a bill over the threat of any credible veto. Second is a judicial game, in which courts engage in the act of judging and thereby interpret the statute enacted by the legislature. This is an interactive interpretive game between the legislative and judicial branches over the interpretation of statutory language and legislative history. Okay, so because the power's out, my fire detectors, smoke detectors are going off, and it's going to make a loud beeping noise, and that's going to get annoying. So I'm going to go ahead and stop with this video and post it. I might extend on it later. But if you don't want to read this paper, I want you to understand about statutory ambiguity and the game that the legislators and the agencies and the courts play. They toss the ball back and forth, and they have a shadow system, and most people don't understand it. And I think Ron Paul has talked about it a little bit, but without going out and searching for the information and reading it, it's hard to really understand what they're saying. But here is a good start. If you're interested in knowing what's going on and you're interested in your freedom, stop going out and picketing or complaining, or spend a little bit of time off Facebook and read this document here. It's really good and very informative, and I think that you will be glad that you did. Okay, so like, share, subscribe, be kind and do no harm and commit no fraud. Have a great day.